What if I told you that the moment your mother or father walked through the doors of a nursing home, they did not surrender a single one of their legal rights? Not one. And yet facilities across this country count on families not knowing that. They count on you being overwhelmed, grieving, and too exhausted to read the federal regulations that govern exactly what that facility is required to do. That stops today. We are going through all 20 rights, one by one, and by the end of this video you will know exactly what the law says. To understand why these rights exist, you need to know where they came from. Before 1987, nursing home regulation in this country was a patchwork mess. It was mostly handled at the state level, enforcement was weak, and congressional investigators documented widespread neglect and abuse in facilities that were taking federal Medicare and Medicaid dollars. Congress finally said enough. In 1987, as part of the Omnibus Budget Reconciliation Act, they passed landmark nursing home reform legislation that for the first time set a clear federal floor of resident rights tied directly to Medicare and Medicaid certification. The law that governs all of this is codified at 42 U.S.C. Sections 1395 I3 and 1396 R, with the detailed implementing regulations sitting in the Code of Federal Regulations at 42 CFR Section 483.10 through 483.85. The core mandate is this: every Medicare and Medicaid certified nursing home must promote and protect the rights of each resident, and help each resident attain or maintain their highest practicable physical, mental, and psychosocial well-being. That phrase, highest practicable, is doing a lot of legal work. It means the facility cannot just warehouse someone. They are legally required to help that person function as well as possible. Here is the scale we are talking about. As of 2023, there are over 15,000 Medicare and Medicaid certified nursing homes operating in the United States, caring for somewhere between 1.2 and 1.4 million residents at any given time. And the money at stake is enormous. A private room in a nursing home costs roughly $9,000 to $10,000 per month on average nationally, though that varies significantly by state. If your family member's rights are being violated, that is not just a dignity issue. It is a financial issue, because those rights are directly tied to whether the facility gets its federal dollars. Right number 1. The right to be fully informed about your health status in a language you understand. This is not vague. The CMS Resident Rights Guidance is explicit. Residents must be told their complete health status, including diagnosis, prognosis, every medication they are taking, whether prescription or over-the-counter, vitamins, and supplements. If English is not their primary language, the facility has an obligation to communicate in a way that is actually understood. This right gets violated quietly all the time when staff give family members updates but do not directly inform the resident themselves, especially if the facility has quietly decided the resident cannot handle the information. Right number 2. The right to participate in your own care plan. Federal law requires nursing homes to develop a written care plan for every single resident and to review and update it regularly. More importantly, the resident has the right to take part in developing that plan, not just be handed a document that someone else wrote. Family members can also be involved, but only with the resident's permission. This matters financially because the care plan determines what services the facility provides, which directly affects what Medicare and Medicaid will reimburse. A watered-down care plan can mean watered-down care, and the resident has every right to push back. Right number 3. The right to access your medical records promptly. The federal regulation says promptly, and that means on weekdays. Many states layer additional requirements on top of that, some requiring access within 24 to 48 hours for review, and copies within a few days. Here is where facilities push back. They may claim records are being organized, or that you need to submit a formal written request and wait. Do not accept that. If your family member or their authorized representative asks to see the chart, that request has to be honored promptly. You can take notes, you can ask for copies, and there may be a reasonable copying fee, but there cannot be a blanket refusal. Right number 4. The right to make decisions about your medical treatment, including the right to refuse treatment. This one surprises a lot of people. A nursing home resident is not a passive recipient of whatever the facility decides. They can say no. They can refuse a medication, refuse a procedure, refuse to participate in experimental research, full stop. The federal rights language is explicit that residents have the right to refuse experimental treatment. Facilities sometimes present residents with consent forms for research studies without making it clear that participation is entirely optional. It is not optional in the sense that they have to participate. It is optional in the sense that they absolutely do not. Right number 5. The right to choose your own doctor. Most nursing homes have what they call a house physician or a medical director who sees residents. That is convenient for the facility, not a legal requirement for the resident. The federal rights framework is clear that residents have the right to be involved in the choice of their doctor. The practical reality, as Maryland's official guidance acknowledges, is that it can be difficult to get outside physicians to make nursing home visits. But difficult is not the same as illegal, and the facility cannot legally force you to use their doctor. If your family member has a long-standing relationship with a physician, that relationship does not have to end at the nursing home door. Right number 6. The right to create advanced directives and have them honored. This covers healthcare proxies, powers of attorney for healthcare, living wills, and even after-death wishes. State law governs the specific forms, but the federal requirement is that facilities must inform residents of these rights at the point of admission and cannot condition care on whether the resident has or does not have an advance directive in place. Here is the part facilities often skip. Many just hand residents a standard do not resuscitate packet without explaining that there are far more detailed options available, including MOLSD and POLSD forms that cover CPR, intubation, feeding tubes, and more. Your family member deserves the full menu of options, not just the one that is easiest for the facility to process. Right number 7. The right to be treated with dignity and respect, including the right to make your own daily schedule. This is one of the most routinely violated rights in American nursing homes, and it is also one of the most underestimated. Federal regulations explicitly state that residents have the right to decide when to go to bed, when to get up, and when to eat their meals. Nursing homes run on institutional schedules because it is easier for staffing. But the law does not say the facility's convenience comes first. If your father wants to stay up until 11 at night and sleep until 8 in the morning, that is his legal right. The facility cannot override it simply because it disrupts their routine. Right number 8. The right to privacy in communications and visits. This one has teeth. Residents have the right to make private phone calls, send and receive emails, and receive regular mail without the facility monitoring or interfering with those communications. They also have the right to private visits with family, friends, clergy, or anyone else they choose, as long as it does not infringe on another resident's privacy or health. During the COVID-19 pandemic, this right collided hard with infection control policies, and families across the country suddenly understood how easily these protections can be sidelined when facilities decide operational concerns outweigh individual rights. Knowing the rule exists is the first step to enforcing it. Right number 9. The right to keep and use personal belongings. Federal law says residents have the right to keep and use their personal property and belongings as long as they do not interfere with the rights, health, or safety of others. That means the facility cannot confiscate your father's watch, your mother's jewelry, her books, her radio, her personal photographs. Families sometimes arrive to find that a loved one's belongings have been removed, supposedly for safekeeping. That is a violation unless there is a specific documented safety reason. The facility has an obligation to protect those belongings, not to take them. If items go missing, that is a reportable issue and can trigger serious sanctions. Right number 10. The right to participate in an activities program. This is not a luxury. Federal regulations require nursing homes to offer an activities program designed to meet the individual needs of residents, and residents have the right to participate in activities of their choosing. Why does this matter enough to be a federal right? Because isolation and inactivity in nursing home residents are directly linked to cognitive and physical decline. A facility that parks residents in front of a television all day and calls that an activities program is not meeting the legal standard. The program has to be designed to meet individual needs. That means your family members' interests, preferences, and abilities have to be factored in. Right number 11. The right to be free from abuse, neglect, and involuntary seclusion. This one seems obvious, but the specifics matter. Federal law protects residents from verbal abuse, sexual abuse, physical abuse, and mental abuse. It also explicitly prohibits involuntary seclusion, which means nursing homes cannot isolate a resident from others against their will. The CMS language is direct. Nursing homes cannot keep you apart from everyone else against your will. This sometimes happens as an informal punishment for residents who are labeled as difficult or disruptive. It is illegal. If a family member reports that their loved one is being kept in their room as a form of control, that is a reportable violation. Right number 12. The right to be free from unnecessary physical and chemical restraints. This is one of the most financially and medically consequential rights on this list. Federal regulations are unambiguous. Restraints, whether physical like bed rails or chemical like antipsychotic medications, can only be used to treat specific medical symptoms, with proper consent, and never for staff convenience or as a form of discipline. The misuse of antipsychotic drugs as chemical restraints in nursing home residents without a diagnosed psychotic disorder has been a long-running enforcement target for CMS. If your family member is being given sedating medications and nobody has explained the medical reason, you have the right to ask, and the facility has the obligation to answer. Right number 13. The right to manage personal financial affairs. This one gets violated in ways that can cost families thousands of dollars. Residents can manage their own money, period. If they choose to have the facility manage their personal funds, the law requires that those funds be kept in a separate account, not commingled with the facility's operating funds, and that the resident receive an accurate accounting on a regular basis. Maryland's official guidance explicitly lists this as a resident right. Misuse of resident funds is a serious enforcement issue that can trigger sanctions, fines, and loss of certification. If you have never seen a statement of your family member's personal funds account at the facility, ask for one today. Right number 14. The right to clear information about fees and services in advance. Before and during a nursing home stay, residents have the right to know exactly what services are available, which of those services are covered by Medicare or Medicaid, which are not covered, and what the charges are for each. This is the right that prevents surprise bills. Facilities sometimes bill for services as if they are covered under the base rate when they are actually extra charges, or they bill for services that Medicare should be covering. If you have never received a clear written breakdown of what is covered and what is not, that is a violation of this right. The rule is written down. Most people just never read that far. Right number 15. The right to appeal a transfer or discharge. This is the right that could save your family member from being pushed out the door the moment Medicare coverage gets complicated. Facilities can only legally transfer or discharge a resident under specific conditions, including a documented safety issue, non-payment, a determination that the resident no longer needs the level of care provided, or facility closure. They must provide advance written notice and a safe transfer or discharge plan. And here is the critical piece. Residents have the right to appeal that decision to the state. In many cases, they can remain in the facility while the appeal is pending. Do not let a verbal conversation from a staff member substitute for a proper written notice with appeal rights attached. Let me pause here and give you a real scenario that plays out constantly across this country. A resident is in a skilled nursing facility after a hospital stay, covered under Medicare Part A. Around day 21, the facility tells the family that Medicare will not pay any more, and they need to make other arrangements. Here is what the law actually says. Medicare Part A covers up to 100 days of skilled nursing facility care per benefit period, with zero coinsurance for days 1 through 20 and a daily coinsurance of $204 per day in 2024 for days 21 through 100. Coverage continues as long as skilled care is medically necessary. A facility pushing for discharge before day 100 when skilled care is still needed is violating both Medicare coverage rules and the resident's discharge rights. Right number 16. The right to make complaints without fear of retaliation. Federal law explicitly protects residents who file grievances about their care or treatment. They can complain to staff, to outside agencies, to family members, to anyone, without fear of punishment. Now here is the reality. Retaliatory discharge, meaning a facility trying to push out a resident who complained, is one of the most serious enforcement issues in long-term care. It happens. But the law gives residents and families a weapon against it. If a discharge notice arrives shortly after a formal complaint was filed, that timing is significant and should be documented. The facility bears the burden of proving the discharge is for a legitimate, legally permitted reason. Right number 17. The right to access the long-term care ombudsman. This is one of the most powerful and most underused resources in the entire nursing home rights system. The Long-Term Care Ombudsman Program is federally mandated under the Older Americans Act. Every state has one. Ombudsmen are trained advocates who investigate complaints about nursing home care, work to resolve problems between residents and facilities, and can escalate serious issues to state regulators. They are free. They work for the resident, not the facility. California's ombudsman programs have documented cases of systematic overuse of antipsychotic medications used as chemical restraints, and their intervention has changed facility practices. If you do not know how to reach your state's ombudsman, that information is available through the Eldercare locator at eldercare.acl.gov. Right number 18. The right to form or participate in a resident council. This is the one that surprises people the most, because it sounds almost too powerful to be real. Federal and state regulations require nursing homes to allow residents to form councils, provide them with meeting space, and critically, to listen to and act upon the grievances and recommendations of the group. Think of it as a resident union with legal backing. The facility cannot ignore the council. It cannot retaliate against council members. And if the council raises a systematic problem, like inadequate staffing, cold food, or medication errors, the facility has a legal obligation to respond. If your family member's facility does not have a resident council, residents have the right to start one. Right number 19. The right to a family council. This is the companion right to the resident council, and it is equally underused. Family members and legal guardians of residents have the right to meet with each other, form a family council, and raise concerns collectively with facility management. If a family council exists, the facility must work with it. This matters because individual family members often feel powerless when raising concerns alone. A family council gives those concerns institutional weight. It also creates a network where families can share information about what they are observing, which can surface patterns of problems that no single family would catch on their own. It is already yours. You just have not claimed it yet. Right number 20. The right to vote and exercise all civil rights. I saved this one for last because it is the most fundamental and the most symbolically important. Entering a nursing home does not strip a person of their citizenship. Residents retain every civil right they had before admission, including the right to vote. Facilities in California and other states are explicitly required to support residents in submitting a ballot, whether in person, by mail, or by other means. This is not optional. If your family member wants to vote in a local, state, or federal election, the facility must support that process, not obstruct it. A person does not stop being an American because they need help with daily living. Now let us talk about the biggest misconception that runs through all 20 of these rights, because it is the belief that makes every violation possible. The misconception is this: once mom or dad is in a nursing home, the facility makes all the decisions. That is wrong in every direction the law can point. Residents retain the right to make medical decisions, choose their doctors, refuse treatment, and participate fully in care planning. A guardian or healthcare proxy only steps in if they are legally authorized and if the resident has been determined to lack decision-making capacity. Until that legal threshold is crossed, the resident is in charge. The facility is a service provider, not a guardian. Another misconception that costs families real money: the belief that the nursing home owns the resident's money. It does not. The law is explicit. If a facility manages a resident's personal funds, those funds must be kept in a separate account, not the facility's general operating account, and the resident, or their representative, must receive an accurate accounting. Misuse of resident funds is a sanctionable offense that can result in fines and loss of Medicare and Medicaid certification. If you have never received a statement showing the balance and transactions in your family member's personal funds account at the facility, request one in writing this week. If the facility resists, that resistance itself is worth reporting to your state's long-term care ombudsman. Here is a misconception that has caused enormous harm to nursing home residents across this country: the idea that if a resident is difficult or combative, the facility can restrain them. The law says no. Physical restraints and chemical restraints can only be used to treat specific medical symptoms, with proper consent, and never for staff convenience or as discipline. Never. The word discipline appears explicitly in the federal regulation as a prohibited reason for restraint use. Bed rails, wrist restraints, and antipsychotic medications used solely to sedate a resident who is inconvenient to manage are all violations of federal law. If your family member is being chemically sedated and nobody has explained the clinical diagnosis that justifies it, you have the right to demand that explanation. There is one more misconception I want to address directly because it stops families from taking action more than almost anything else: the belief that if you complain, they will kick your family member out. The law explicitly protects the right to make complaints without fear of retaliation. Retaliatory discharge is a serious enforcement issue precisely because it does happen, but it is also illegal, and facilities know it. If a discharge notice arrives shortly after a grievance is filed, document the timeline, contact the Ombudsman, and request the written notice with the specific legal grounds for discharge. The facility must provide that notice, and you have the right to appeal. Silence is not the safe choice. Silence is what facilities are counting on. Let us talk about the leave question, because this one genuinely shocks people. Many families believe that once their loved one is in a nursing home, they cannot leave for visits or overnight stays without losing their Medicare coverage or their bed. That is not accurate. Federal guidance for residents specifically addresses the right to leave for day visits or overnight stays as long as the doctor determines it is medically safe. There are procedures for what is called therapeutic leave, and Medicaid has specific bed hold policies that vary by state. The rules are not simple, and they do vary, but the point is that leaving for a family holiday or a weekend visit is not automatically a forfeiture of rights or coverage. Ask the care team about the specific policy before assuming the answer is no. Here is something the 2016 update to the requirements of participation made clearer than ever before. CMS issued a major rule in 2016, phased in through 2019, that reorganized and strengthened the resident rights regulations at 42 CFR Section 483.10. It explicitly expanded protections around self-determination in daily routines, strengthened the grievance process, improved access to ombudsman, and clarified the rules around abuse and restraints. This was not a minor administrative tweak. It was a significant restatement of what facilities are required to do. If anyone tells you that nursing home rights are vague or unenforceable, point them to the 2016 final rule. The details are there. They are specific. And they are enforceable. The enforcement mechanism behind all of these rights is worth understanding because it is what gives them real power. Every Medicare and Medicaid certified nursing home is subject to periodic state surveys conducted on behalf of CMS. Surveyors use a system of F-tags, which are specific citation codes tied to regulatory violations. An F-tag violation for a resident rights issue can result in a plan of correction, civil monetary penalties, denial of payment for new admissions, and in serious cases, termination from the Medicare and Medicaid programs. That last consequence, losing the ability to bill Medicare and Medicaid, is an existential threat to a nursing home. It is why the rights in OBRA 1987 have teeth. The facility's federal funding is the leverage. Medicaid deserves its own moment here because roughly half of all long-term care spending in the United States flows through Medicaid, not Medicare. For many nursing home residents, Medicaid is the primary payer. And every single one of the 20 rights we have discussed applies equally to Medicaid residents as it does to Medicare residents, because OBRA 1987 tied both programs to the same resident rights framework. A Medicaid resident is not a second-class resident. They have the same right to care planning participation, the same right to refuse treatment, the same right to appeal a discharge, and the same right to access the Ombudsman. If anyone at a facility treats a Medicaid resident differently than a private pay resident in terms of rights, that is a violation. Let us talk about what to do if you believe a right is being violated, because knowledge without action is just frustration. Step 1. Document everything. Write down dates, times, names of staff involved, and exactly what happened. Step 2. File a written grievance with the facility. Federal law requires facilities to have a grievance process and to respond to it. Step 3. Contact your state's long-term care ombudsman. You can find them through eldercare.acl.gov or by calling the Eldercare locator at 1-800-677-1116. Step 4. If the violation involves potential abuse, neglect, or financial exploitation, contact your state's Adult Protective Services. Step 5. If Medicare coverage is being wrongly denied or cut, file a formal appeal through the Medicare appeals process. These are not suggestions. These are the mechanisms the law built for exactly this situation. CMS publishes a tool called Care Compare, which is the updated version of what used to be called Nursing Home Compare. You can find it at Medicare.gov. It shows inspection results, staffing data, and quality measures for every Medicare and Medicaid certified nursing home in the country. Before your family member is admitted to a facility, or right now if they are already in one, look it up. Look at the inspection history. Look at whether the facility has been cited for resident rights violations, abuse, or improper restraint use. This is public information that CMS has made deliberately accessible. Use it. A facility's track record on resident rights is visible before you ever walk through the door. Staffing levels are not technically one of the 20 rights we covered today, but they are directly connected to whether those rights are honored in practice. CMS has been pushing toward minimum staffing standards for nursing homes precisely because understaffed facilities are where rights violations cluster. When a facility does not have enough nurses and aides to meet residents' needs, the first things to go are the dignity protections, the schedule flexibility, the individualized activities programming, and the careful medication management. The rights exist on paper in every facility. Whether they exist in practice depends significantly on whether there are enough staff to implement them. Staffing data is on Care Compare. Look at it. Here is the broader picture I want you to carry with you. The nursing home system in this country handles over 1.2 million Americans at any given time, and it costs families and the federal government enormous amounts of money. The rights framework that OBRA 1987 established was a direct response to documented, widespread abuse of vulnerable people. Congress built these protections into the Medicare and Medicaid funding conditions because that is where the leverage was. Every facility that takes a Medicare or Medicaid dollar has agreed, as a condition of receiving that dollar, to honor these rights. This is not a loophole. This is the law. Your law. And it applies to your family member right now, today, in whatever facility they are in. I want to give you a practical checklist you can use the next time you visit a family member in a nursing home, or have a conversation with facility staff. Ask to see the written care plan and confirm your family member was involved in creating it. Ask for a copy of the facility's resident rights notice, which they are required to give at admission. Ask for a statement of any personal funds the facility is managing. Ask whether a resident council exists and how to access it. Ask for the name and contact information of the assigned social worker. And ask what the facility's grievance process looks like in writing. These are not aggressive questions. They are the basic due diligence that the law assumes families will do, and that facilities assume you will not. If you are watching this because a family member is already in a nursing home and something feels wrong, I want you to hear this clearly. You are not being paranoid. The feeling that something is off, that your loved one is being managed rather than cared for, that information is being withheld or decisions are being made without proper consent, that feeling is often grounded in something real. The rights we covered today exist precisely because Congress recognized that this population is vulnerable to exactly these kinds of quiet violations. You have tools. You have the Ombudsman, the grievance process, the Care Compare database, the Medicare appeals system, and the right to access records. Use them. Your family member paid into this system their entire working life. If this video helped you understand something that nobody ever explained to you before, share it with someone who needs it. A sibling who is helping manage a parent's care, a neighbor whose spouse just moved to a facility, anyone who is in the middle of this and feels like they are flying blind. Drop a comment below telling me which of these 20 rights surprise you the most, because that helps me know where to go deeper in future videos. And if you are not subscribed yet, this is the channel where we go through federal benefit codes, Medicare rules, and the regulations that govern what older Americans are actually owed. Every dollar, every right, every protection that is sitting there unclaimed. They count on you not knowing. That stops today.